Hello, and welcome everyone to today's webinar. This is one of the many content pieces that ActiveProspect is putting together in the weeks and months ahead as we help the lead generation and performance marketing industry navigate the most recent FCC one-to-one consent rules and other updates in the TCPA, or Telephone Consumer Protection Act. We believe the content we're putting together here is going to help you decode these changes with more confidence and a focus on compliance. Today's topic, don't panic, prepare, navigating the undefined world of robocalls and robotext. So some housekeeping items. First, in our webinar platform, there is a chat icon in the upper right and also a questions icon. Please use the chat section for general comments and interactions with the other participants here today. And please use the question section if there are questions you'd like to pose to us. We're going to leave time at the end for review and response to these questions, but we'll also do our best to keep an eye on them during the session to see if we can provide some quick answers. We're going to share a link to the live recording that's going to be emailed shortly after today's session. I'm Benjamin Farah, the Director of Privacy, Security, and Compliance at ActiveProspect. And for the last 10 years, I've worked for companies in the performance marketing, advertising agency, and market research space, including WPP Kantar and Dentsu, with much focus on privacy data regulation and compliance during that time. Before that, I worked at Ernst & Young in New York as an IT controls auditor in financial services, and then on the firm's data privacy compliance team. And I started my career at Ochsner Clinic Hospital in New Orleans, Louisiana, in internal auditing, covering healthcare and insurance. And my previous roles were always in functions and departments that were focused on legal, compliance, privacy, IT audit, and data security. And one clear theme has followed me throughout my career. In every one of these industries and jobs, a significant data regulation or law was passed. And I was on the team responsible for reviewing and translating the new rules, seeking clarity, and then establishing a compliance program. So regulations such as HIPAA, SOX, GDPR, state and country data laws, as well as industry-specific regulations. And now for a brief background and introduction, I'd like to pass the mic to my first co-host today, Tammy Glover-Fowler, Compliance Officer at Convoso. Tammy.
Hello, thanks for having me. Excuse me. So I've been working in the telemarketing space, legal and regulatory compliance for over 17 years. Most of that time was spent in the telemarketing space, 10 years of those. I started Convoso's compliance department over 2 years ago, and my oversight is with TCPA, TSR, state regulations. Prior to Convoso, I worked for Bridgestone America's law department as a compliance specialist and as a compliance bank auditor. So my oversight was with OCC regulations, and all the various banking regulations. And then prior to that, in my telemarketing space, I worked for a large telemarketing company in Ohio who had brick and mortar call centers all over the state, 35 to 40. So I managed compliance for all of those centers. And then finally, I have my master's degree in business ethics and compliance.
Excellent, Tammy, thank you, and really happy to have you with us today. It's an excellent background, particularly for the topic we're going to dive into today. And next, Puja Amin, attorney and partner at Troutman Amin firm. Puja, hello.
Hi, I am Queenie of TCPAWorld, and it's Puja Amin, not Amin. Puja Amin of Troutman Amin LLP, and I'm also board member of REACH, Responsible Enterprises Against Consumer Harassment. For you folks who don't know who I am a TCPA defense class action attorney and compliance guru, if you will, in the TCPA space, in the privacy space. My partner, Eric J. Troutman, the czar, and I built this firm to really focus on TCPA class litigation to help companies and brands and call centers all across the country to help them get compliant with all these ticky-tack rules that you're about to hear about today.
Excellent. Thank you. And let's jump into it. So one of the first questions we hear often, but you're uniquely qualified participants, subject matter experts here today, robocalls, right? We hear the term robocall, robotext, but what are we talking about here? What does this specifically mean? Is this defined?
So under the TCPA currently, right, the term robocall or robotext is not defined. However, there is a pending bill that we're not going to get too much into the weeds today, the Do Not Disturb Act, which is looking to essentially change the definition of an ATDS under the TCPA with robocall. That bill hasn't been passed. We predict there's going to be a ton of changes before it actually passes. For purposes of today, the term robocall and robotext is not defined. What is defined under the TCPA and by courts is a definition of an ATDS. So on a high level, right, the TCPA prohibits telemarketing calls made using regulated technology, which regulated technology includes artificial voice, pre-recorded calls, dialers, and now, as of recently, AI use, without the prior express written consent of the consumer. The TCPA's DNC rules prohibit making calls or text messages to numbers on the national DNC without prior express invitation or permission, or without what we call an EBR, an established business rule.
Excellent, excellent. And there's been a lot of developments over the last 4 months from the FTC, one in November, December, and January, iterations of that. The closes the lead generator robocall, closes the lead generator loophole, adopting robotext rules. This was called the advanced methods to target and eliminate unlawful robocalls. And then in January, empowering consumers to block robocalls and robotext. This is sort of AKA known as the revoking components of their developments. And then recently a declaratory ruling about AI. So lots of focus over the last 4 months in this space for the lead gen and call center services for sure.
Yeah, the FCC, the state AG's offices, the courts have been so busy around this TCPA space. I mean, Troutman and Amin, as a result, has been so busy keeping up with these rules. And, if we talk a little bit about how we got here, right? The lead gen industry, there wasn't trade organizations or really any other law firms out there that were helping the lead gen industry self-regulate itself. And, my partner and I, we started Reach to help assist folks with the proper standards to stay compliant with the TCPA. Around that same time, the FCC issued what you call a notice of proposed rulemaking, an NPRM, early last year, really looking to close down the lead industry as a whole. And they snuck in some really sneaky language in their NPRM that no one was focusing on except really our firm and TCPAWorld. And that sneaky language was around this one-to-one consent that they eventually ended up adopting in its recent ruling, as many of you folks know. Before this ruling came out, the lead gen industry would list out tons and tons of marketing partners on their websites. You go on these websites, you're familiar with it. It might be a website you're trying to send a lending product, but then you get sold to sell solar panels. It was so discombobulated, and really that was trying to hone in on that and prevent folks from getting calls that they weren't necessarily signing up for. So, they developed this one-to-one rule where they're trying to eliminate lead generators altogether. Reach at that time did a ton of work to work with the FCC to get them to understand the value of the lead gen industry and the value of the middleman marketer. It is so extremely valuable to the consumer, and the FCC completely was missing that point. So eventually what the commission did was they came to, I guess you can call it a middle ground, depending on who you are, right, what position you're on. And essentially the rule now is that, okay, folks, you can still have that middleman marketer, right? And a consumer can still go on, a web page and still get to, say, the Loan Depot of the world or the ultimate seller through a marketer, but it has to be on a one-to-one basis. So what does that mean, right? That means that publishers, the lead generator, the marketer has to include a single name that a consumer is agreeing to receive calls or text messages from that seller and nobody else. It's a huge, massive change. The order does state that you can have multiple names on the form now, but the consumer has to really check each individual that it is giving consent for from a singular seller. Huge change, and that's why we're here. We're here to talk about how to navigate this new world, what the consent language looks like now. And we've outlined the requirements of what we think Troutman Amin 15, if you will, of what this new ruling is going to look like and how it impacts consent.
Yeah, and Tammy, your role as compliance officer at receiving these rules and translating them for years. So what's been, as you've been following these developments along from a call center perspective and developing standards and codes, what's your comments around it?
Yeah, I mean, these are targeted towards companies who are conducting abusive marketing, telemarketing practices. We can't be surprised that these efforts are out here. It's just important to understand the process of telemarketing. You just got to go through the test. Do I have a right to call this person? Do I have consent? Did I scrub against the national do not call list? It's really about valuing the lead that you get and taking care of it and really converting it into an established business relationship. From my perspective, as a company with the dialer software working for telemarketers and BPOs, it's just important to understand that you're trying to develop a customer base. And so the one-to-one lead consent, once you get your head around that and you develop processes in place to comply with that, you'll just be able to take care of your lead a lot better. And you can convert that lead. Once you have a transaction with the person, you can convert that lead into an established business relationship, and then you're no longer bound to the one-to-one consent because you're starting to establish a customer base, and now you can call these people. You have 18 months to call someone once you establish a business relationship, and you have 90 days if it's an inquiry. So from where I sit, it's just teaching our clients to value your lead, obtain it properly based on the rules, and take care of it and convert it into a customer base.
Yeah, and to piggyback on what Tammy's referencing when she's talking about the EBR, the inquiry rules, those are going to be largely impacted by the DNC rules, right? So this FCC ruling, it matters what technology you're using here, right? So presumably this new FCC ruling impacts regulated technology only. Calls to the numbers on the DNC list may be completely out of scope for this with this new FCC regulation. The ruling only addresses the prior express written consent rules around using regulated technology, pre-recorded calls, AI, dialers, etc. However, the FCC did not address or attempt to revise the definition of prior invitation or permission under the TCPA's DNC rules. So of course, you gotta be wary. You have to have an asterisk around this because they could just start interpreting the exception narrowly, right? Kind of like how the FCC has been doing with pre-recorded messages. But if you are, according to this rule, now we don't know how this is going to play out in court or how the plaintiff's bar is going to get in sneaky lawsuits around this, but if you are using a true manual system, right, which involves human intervention, then likely this rule is not going to apply to callers who are not using dialers, pre-recorded messages, AI messages. And, it really encourage you to understand whether you're using an ATDS. I know a lot of folks think they're not using an ATDS or they think they're using a manual system, but you really have to get that vetted by outside counsel. A lot of what we do day in and day out is we review source codes to make sure that you're not falling within the current definition of an ATDS. These days of manual and click to call, they're obsolete, right? Right now, all that matters is if you're using human selection versus an ROSMG usage within your dialer. So before making any type of outreach, it is so important for you to first understand whether your system is an auto dialer or if it's a true human selection system.
Yeah, excellent.
Right.
Let's do a poll right quick to see. This will be good for the audience out there. Let's ask this question that relates before we go a little bit deeper into the manual dialing and auto dialing. So simple poll, just trying to get a pulse check. Who is not using an auto dialer? Get 3 responses saying I'm not using an auto dialer, I am using an auto dialer, or I'm really not sure. So those are the 3 categories, and we'll take a look at the responses in a few minutes. But let's dig in a little bit deeper in the manual dialing and automated dialing topic here.
Yeah, Ben, I do want to caution folks before you answer that question, not that it's going to impact you if you answer a full question, but I really want you to think about the definition of a dialer. Under, according to the Supreme Court's Facebook decision, which is relied on by courts and plaintiffs' counsel these days in the TCPA industry, the Facebook decision looks at whether the system uses random or sequential number generator for any process, even remotely connected with the storage of phone numbers. So, that can mean that if you have any code with the capability to create telephone numbers randomly or sequentially or otherwise, you are going to be considered a dialer. Additionally, no randomizers to number sequencers can be used in the system to respond to determine, for instance, what numbers are going to be dialed, to determine what sequence in which you're going to dial your number. You cannot have any randomization or sequencing going on on the back end of your coding in order for you to be a true human selection system or a manual system, if you will.
And Tammy, Convoso has really had to account for this in its solutions that it helps bring to market. If you can tell us a little bit about that, that'd be great.
Yeah, certainly. I think all dialing systems should have that option separate from its automated system. I worked in call centers way back in the day, brick and mortar, and even then there was an option to auto dial. You need that. You need to be able to slow down, dial your leads, dial your customer base, slowly take care of your lead. So every dialer should have that option to slow it down and auto dial separate from your automated system. And so we do have a manual dial selection that requires human selection, but we still get your consent. You still need to just get your consent. That is your exemption to using an ATDS, is to obtain prior express written consent. It's just important to have that. So, but we do have that option.
And I've heard the term human selection. I'd love to know a little bit more about what we're referring to when we talk about that with these solutions.
Go ahead, Tim. Sorry.
No, go ahead, Puja.
Well, as I mentioned, in order for you to be a true human selection or manual system under the current state of law, you have to strip out all the coding that has to do with anything with randomizer or integer generating to assign any type of priority to dialing the texting record or to determine sequences or segments for instance, load balancing. There's so much that goes into reviewing the source of your dialer to determine whether it's going to be a dialer, a true human selection system or not. And, as I mentioned, this is probably something that's you can't determine unless you have outside counsel reviewing your system and,
exactly.
and blessing it as a non-dialer or non-ATDS under the current state of the law.
Yeah, absolutely, Puja. I agree with you 100%. And we have had ours examined by legal counsel and certified. But even with that, we still have your consent. So.
Yeah. I agree with you on that, Tammy. Even if you are assuming you're not using a dialer, and if we want to leverage the fact that the FCC did not issue the prior express invitation rules, we have to be careful here, right? Because you have this organization called the NCLC, where they're saying that the definition of prior express invitation or permission always required one-to-one consent, right? So while the FCC did weigh in and no court has so far agreed, State AG's office, the NCLC, they are pushing for this definition that the one-to-one consent requirement was already there for the DNC rules. So it'll be interesting to see how this gets challenged in court, especially by the plaintiff's bar. And, they may say there was no modification because the NCLC and State AG's office said this requirement was already there. So we just don't know how it's actually going to be played out. So even when you're using a human selection system, you still want to obtain at least the prior express invitation, and where you can, you want to obtain that Troutman Amin 15 consent level before making any kind of marketing outreach.
Yeah, that's great. Let's see if the results of our poll, just sort of a quick pulse check of who we have here. So we got a little over half said they're not using an auto dialer, just under 30 using an auto dialer, and 15% not sure. So interesting representation sort of across all of these categories. Puja, you mentioned the Troutman Amin 15. I'd love you to share more context and information about that. That's a great resource that's been published. You guys could have kept it behind the curtains and have it right there on your office table for reference, but you shared that with the industry. So please tell us more.
Yeah, so that is essentially going to be your cheat sheet, right? There's other firms and other lawyers who probably charge you, an hour to just dream that up. We have it out there on TCPAWorld, all for free, to really help the industry understand what consent should look like going forward once this ruling takes place. We still are at least a year out, right? But for folks who are looking to navigate and change their consent language starting now, it's a very, very helpful tool. Were you able to drop it in the chat box? I can do that right now, too.
Yeah, we've got that ready to go, sure.
Perfect. So the Troutman 15, when you're looking at this, it's going to take into account all the new requirements under the FCC's one-to-one consent rule. And that's going to mean it gives you a nice outline of how you can identify different sellers, where your select all button should be placed, where your submit button should be placed, just different requirements, including the e-sign proponent of the new ruling that is required now, the ones that were already included, which is whether you're using an auto dialer, pre-recorded messages, whether you're sending text messages, and also where you can provide, you can call a number to obtain the services without having to provide your prior express written consent. So it's a really neat tool that we have placed there for free for you folks to utilize when you start navigating the new consent rules.
I'm glad you guys offer that.
Yeah, it's a neat little tool, and a lot of folks are having trouble understanding what the one-to-one consent rules look like, right? The FCC now is requiring marketers to claim one-to-one consent before contacting consumers. Once this rule takes place, businesses and websites that generate leads, especially those that have comparison shopping websites, for instance, will not be permitted to obtain a single consent to cover regulated technology calls and text messages from multiple sellers. Rather, it has to be obtained, as we have already discussed, separately for each identified seller. You can list out different sellers, different marketers, but you want to be, understanding the consumer's view of not listing hundreds and hundreds of sellers, and all the way on the bottom of that consent website is a submit button. And folks are already trying to get tricky and do a big, large select all button. That's probably not going to pass muster either. You're going to have a very clean website layout that is consumer friendly, and the consumer can and knows what seller they're actually picking before clicking the submit button or the continue button.
Yeah, excellent.
Transparency.
Yeah, and that's really what it's about, and that's the theme. If you try to take the high view of all this, it's transparency. That's the direction the regulators are going, and attorney generals. Understand the position of the consumer, place in front, put yourself in their shoes of their thinking. Transparency. Do they understand where the data is being shared? Do they have a voice? Do they have a choice in this? That's clearly the theme of all of these components of the FCC and the FTC as well, is ringing true. And Tammy, as you mentioned, it's probably not as important always to get caught up in some of the components. It's capture consent, get consent, whether you may or may not technically need it, or your analysis is to try to not capture it. It's just the best practice, and it should be done and performed. And ActiveProspect has some great solutions for this, which is Trusted Form. We've got a solution that does certify, verify, and retain, 3 different variations of that, which is great. It captures the consent transaction on the web form exactly as it happened. This could be for first parties. This could be for third parties. and can also now allow analysis for compliance officers afterward if you're using third parties to see what's the consent language that was being presented and captured. So it really gives you transparency and visibility to understand the risks that you might be taking in this language as well. We've also put forward a proposed ping pick post solution for comparison sites. This is a model that was sort of when these developments with the FCC was closing the lead generator loophole, one-to-one consent, was very concerned about how will this model even continue to exist. This is a proposed model. We'd love people to visit the website, take a look at our visuals, and we want the industry's input on that. Is it good? Where could we improve? Critiques, everything is also encouraged and invited for that as sure.
Yeah, Ben, and you mentioned, ActiveProspect and the solution that they give. I want to dive in a little bit deeper into the additional requirements other than the one-to-one consent. I want to also clarify the seller in this context for those folks who are in the lead gen industry. Seller is the ultimate good or service provider. It is not the lead seller. So I just want to, clarify that. Additionally, the FCC, while it's not limiting the number of telemarketers that a website can list out for the purpose of obtaining prior express written consent, as a practical matter, the parties listed that you are looking to list out must be similar because the content of any calls or text messages must be logically and topically associated with the form where the consumer gave consent. Now, the FCC has declined, they failed to adopt a definition of what logically and topically means. And all they've mentioned is that texters and callers should limit content to what consumers would clearly expect. And so, I predict there's going to be a lot of litigation around what logically and topically means and how folks are going to have to navigate that space as well. To illustrate their intent behind this new ruling, the FCC did state that consumer giving consent, for instance, on a car loan comparison shopping website does not provide you consent to get calls, or as they say it, robocalls or robotexts about, say, a loan consolidation. So for you folks who are operating in the multi-vertical leads, you really have to start thinking about this and building out, new web pages that are vertical specific or logically and topically related before you're obtaining this consent. Because I tell you, this is a completely new avenue for the plaintiff's bar to start filing lawsuits, one that really didn't exist before. We see already so much pushback on dark patterns and whatnot. So you have to be extremely careful because the FCC is looking to shut down all those dark patterns that we see day in and day out. Mm-hmm. And additionally, the FCC also now imposes a new record keeping requirement. So now the burden of proof is going to be on the ultimate seller, so the lead buyer in this context, to obtain that proof of consent, the ActiveProspect trusted form certificate, before they make that call. So, in the world today, we're used to the lead sellers holding on to that consent record. That's no longer going to be the case. And that will be interesting to see how the lead buyers are going to navigate that, working with their lead sellers, potentially including on contract terms, understanding when they're going to be receiving that consent record. That's going to be a huge shift for the lead buyers because it's something that they don't necessarily have to operationalize right now within their organizations.
Right.
And when I hear this with those challenges and translations and interpretations, what that always means to me is it's really important to have a membership association that is looking and advocating for the industry in this space. So I certainly want to give a shout out and plug to REACH, Responsible Enterprises Against Consumer Harassment, doing great work to look at these rules and then the challenges. Encourage people to join. If you're not already a REACH member, you can get more information. We'll post a link here, but it's at reachmbc.com. So we certainly encourage everyone to take a look and join so you can be part of these meetings and discussions and get closer to the translations of these unique challenges that are affecting the industry ahead.
Yeah. And to go back to what Puja was talking about, logically and topically, they did not define that because it's almost impossible. How can you even provide definitions for that? That's something that's just going to have to be argued in the end. I've not seen telemarketing regulations defined with such distinctiveness unless it's like, you know, number of months or number of years, record keeping requirements, things like that. But logically and topically, yeah, that's just too difficult.
Yeah, and it's gonna be difficult for not only the lead generators, but also for the companies that are trying to obtain consent on behalf of their entities, right? So you take, for instance, Loan Depot, who's offering a 30-year fix, right? Does that provide them consent to get calls involving another mortgage product or a personal loan, for instance, or a HELOC?
Right.
Student loan, perhaps. Right, a lot of these brands and these big call centers are used to being able to call consumers for all the offerings that the institution offers. And so the direct party consent issues are going to be the one party consent issues. And to me, logically, if you are applying, for instance, a 30-year fixed loan, that does not mean that you can call me for a student loan.
Right.
Even though it's from the same organization, right? Someone like Loan Depot. So, I mean, it'll be really interesting to see how it comes through. I do think that if the industry is being smart and thoughtful of creating their websites and their consent flows, hopefully, right, the courts and the FCC and the AG's office won't, file too many suits or too many fines around this, but it's going to be really interesting to see how it plays off. So you have to track really carefully.
Right. And also speaking on the matter of getting that consent directly from your vendor in time while you're making that call, I like how they did not specifically give that time frame either, because they don't understand how that's going to work. They can only make the statement that you need to have that consent in hand. So like Puja said, companies will need to make an arrangement to constantly flow that consent to the seller, the lead buyer, to constantly just keep it going, because you never know when they're going to try and define a time frame for that.
Correct.
Okay, and other developments that are related, because we're talking about a technology topic, the recent development with the declaratory ruling about the FCC referring to AI. Who should be great if you can give us a rundown. This was very recent, although if you follow the trends, it was heading towards that. But what's the latest update from the FCC in February?
Yeah, so I'm not going to spend too much time on this one, Ben, because I really want to get into the revocation rules, because that one is huge. That one, to me, is bigger than the one-to-one consent ruling. But the AI ruling, right, a few weeks ago, the commission came out. This shouldn't be a surprise to anybody, because last October, there was what you call a notice of intent, where the commission essentially asked for comments on how it should regulate artificial intelligence, AI voice, and the ruling came out that AI voice, it's not illegal, it is just now governed by the TCPA rules. Similar to how I outlined before in the beginning of the call, that there's regulated technology, requires prior express written consent. So now in order to use AI voice, artificial voice, which is obviously regulated and obviously falls within the definition of artificial voice, as the FCC has also agreed, you have to obtain prior express written consent. Going forward, you're going to have to obtain that Amin 15 within a year, but it's not illegal. They have just stated that it falls within the TCPA's regulated technology rules. Shouldn't be a surprise to anyone in this industry.
No.
It's a surprise to you. Shame on you. This was just obvious. Just incorporated into your head that it falls within the TCPA now.
Yeah, shouldn't be a surprise to anyone. Artificial voice, pre-recorded call, no surprise.
Yeah, but the theme continues. Make sure you're capturing consent for use of those things, and then you can gain the efficiencies that can help be unlocked by these really, really interesting technologies that are being used in call centers around. So let's unpack the summary of the revoking consent rules, which just happened right at the end of January. This was very significant, snuck in, I think, the last week, although there was developments in the previous years, but that's when the FCC did their NPRM on the revoking consent component.
Yeah, so this one is huge. the new revocation rules limit the time you have to honor revocation to 10 days. But more importantly, it also brings now marketing and informational DNC revocation rules into alignment. At its February 19th, I believe, meeting, the open meeting, the FCC adopted a bunch of changes to, as quoted, to straighten a consumer's ability to revoke consent, and indicating to the caller that they no longer want to receive calls or texts. The order was designed to make consent simple and easy, and it adopts various very important rules that are going to completely change how you operationalize DNC requests. The first one, as I mentioned, is now you have 10 days to honor a DNC rule. Previously, there was no legal requirement on how much time you have to honor a DNC request. Now the FCC has stated you have only 10 days. I expect there to be a ton of litigation around those folks who are processing the DNC request on the 11th day, the 12th day, the 13th day. However, I also see that as something that a lot of companies are going to be able, it's going to be a quick fix, right? A lot of folks aren't going to have that much difficulty. I predict just a switch or a setting within their systems. Where they are going to have the difficulty is when they're transferring the DNC request amongst different, different call centers within their organization, or to their, outsourced call centers, et cetera. So it's a limited time frame, but it's better than what they were looking to do, which was, I believe, a 24 or 48-hour period.
Yeah.
Now, thank goodness, right? Because that just was unacceptable and very unreasonable. So now we've landed on this 10-day one. Next, the FCC rules that a stop to a marketing message prevents any further calls or text messages in the absence of a consent exception. A stop to an informational message, however, revokes all ability to text or message, even for emergency or informational purposes. Right, so wrapping your head around that, you get, for instance, fraud alerts from your bank, and I respond saying stop. You now, organization, can no longer send me text messages or calls regarding late payments, regarding any emergencies, regarding anything that would otherwise have been exempt under informational text messages. And that's huge because so many companies rely on those automated informational text messages to stay in touch with their consumers. Now, as soon as you get a stop notification, you have to stop all of it. So that it'll be very interesting to see how creative folks get in the space. I'm already seeing folks pivot on how they're going to present their stop out notification, right? Like stop out to receive billing notification. What does that look like? If I press stop, does that only stop me out of informational billing notifications, or does that too stop me out of other type of informational messages? So that will be an area where folks are going to have to pivot a little bit, be creative in their opt-out notifications. Eric and I are going to do a huge deep dive at the upcoming DNC Summit here in a week, less than a week, of how folks can be creative and really utilize this new ruling to reach out to their consumers. Further, the FCC ruling provided this revocation, clarification, and non-response order where the FCC codifies that a confirmation text may include a request for clarification from the text recipient if they've consented to several different areas of receiving messages. So what that will allow you to do, right, you will have the opportunity to specify which types of text messages the consumer no longer wishes to receive, including please confirm whether you want to opt out of all text messages, right? So there is an opportunity to send that one-time clarification message to the consumer. However, if the consumer does not respond back to you, you have to treat that as a global opt-out. So you have to stop all messages. They also included this 5-day turnaround for the confirmation text message, which makes sense, right? You don't want to be texting a consumer after 5 days to clarify why they opted out. And if you go beyond that 5 days, it's going to be the burden on you to show why it was reasonable. So I would recommend best practices just to stick within that 5-day window to clarify what the stop out request was for. And then they have another provision in the order, which is for those of you folks sending text messages that don't have reply capabilities. If you're using that, you have to provide a few disclosures on how they can opt out, whether it's, through a website link or instructions to text a different number to revoke. You have to give another alternative way if they cannot reply directly back to that text message.
And what was the date for that one? The implementation time frame for that? That's one thing I wasn't quite sure on either.
Yeah, I've been seeing a lot of confusion around this and different articles and other lawyers who don't really know what they're talking about. But certain amendments, right, are going to be required to be implemented, I think, 30 days after the federal registrar. The 10-day revocation rule, for instance, will not be required until 6 months after the FCC has completed its review. And I think the intent here was that the FCC understands that 6 months is going to be necessary in order to make all these necessary changes, especially on the informational versus marketing text message revocation alignment. So you'll have 6 months once they complete their review. They have not yet completed it. I have not seen any notifications, but assume for the purposes of the rules we're discussing right now, it's going to be 6 months after.
And I think it's good to talk about how it used to be. We used to take 30 days because that's how often we would subscribe to the national DNC list and the state list. And so when someone would give an opt-out request or a DNC request, the regulations allow you that 30-day window. But really, in the day and age we're in now, you can really do it in 10 business days. And then if we look at express consent versus written consent, how they're combining all that together now. People don't understand, if you give your phone number to your bank or your doctor's office when you're filling out your medical information, you've given them express consent to call you and text you and give you informational messages only. So we don't even realize we're doing it. So now when we get an informational text and that opt-out is there, we're really going to lose those alerts that we want to receive. We don't realize we're doing it until we proactively provide written consent to a company. And then we're more aware when we get texts and calls from them, and we're more eager to opt out because we don't really want to be contacted. But there's a difference between express consent and written consent, and we don't realize we're doing it when we give express consent. But now we're going to have to pay attention because I want my fraud alerts. I've got to be careful that I don't opt out of that.
Correct. Yeah, and I wanted to clarify one thing. I think I said 5 days. What I meant was 5 minutes for the revocation confirmation text message that you're allowed to send over. The informational, and a lot of folks aren't paying attention to this, Tammy, right? Everyone's very focused on the one-to-one consent rules, which they should be and they ought to be. But these new revocation rules, they are just massive. And I'm not hearing enough folks talk about this. And that's scary. And I remember, I walked into the czar's office just a few weeks ago, and it's like, you keep talking about this one-to-one consent ruling, which is fine. I understand the importance of it. But to me, the biggest piece right now is the informational marketing opt-out dynamics that are going to take place here.
Mm-hmm. Right.
Yeah, absolutely. It was very impactful. And do we expect to hear a little bit more clarifications from the FCC or guidance? How does that usually work in the weeks and months ahead?
I think these are going to be the rules, right? Once they complete this review, Reach has not submitted comments in regard to this piece. And so, as of February 19th, the open meeting adopted this order. And so this is going to be the law. So folks, have to wrap their heads around the one-to-one consent and then also the new revocation rules.
Yeah.
Well, and the reasonable piece part of that, the reasonable means part to opt out too. You should be able to have reasonable means to opt out. Perhaps you don't want to do it on your phone. Perhaps you want to go to their website, but can you walk into a department store and hand your opt-out to a cashier? That's not reasonable. They don't handle those controls, but it also has to be a reasonable means to opt out. That has to be provided as well.
Yeah, Tammy read another critical piece of the ruling was the order revoking consent, providing a way to revoke consent in a reasonable way, and also the standardized list of specific revocation words. The FCC also included, under the new rules, consumers can opt out using words as stop, revoke, end, and opt out, and they specified those actual specific words. But they also state that consumers can use other words that would be a reasonable method of opting out. They don't clarify, they didn't give a list of words. And, a lot of companies and a lot of platforms already have, they operationalize very similar words, reasonable words, right? Someone telling you to F off, for instance, I think that means opt out, right? So using your brain and looking at it from the lens of being a consumer's reasonableness of opting out, you really have to be able to process that, or at least work with vendors or platforms that are able to process those different stop requests. It's amazing how many times I still hear that folks only have operationalized the word stop for a DNC request. So I'm sure the FCC took note of that, and they provided a few words, very few words, but they did not provide an exhaustive list of what's going to constitute as a DNC.
Yeah, and from a compliance officer, compliance view perspective, I mean, all of this is to try to be optimistic. It's an opportunity to take a look at your business models and see where you could improve, provide more transparency, think from the consumer. So it's going to force that. And of course, make sure you have great legal counsel aware for those hard to answer questions. Some of them may be easier than you think, but it's great to have those advocates who can answer those quickly for those things to help, control the risk that you might be facing in the lead generation and call center space. Let's shift to some questions. We got a number of questions here that came in during the session today. I'll try to summarize a few of these. We'll try to do this in lightning round format. Not all of these will have the context, of course, but we'll grab some. A question about warm transfers, purchasing warm transfers, and how this is going to be impacted.
Yeah, so the warm transfer space, that's going to be very interesting, right? So if you are transferring a call to the ultimate seller, you have to keep in mind the consent rules, right? So assuming you, for instance, have received consent for Loan Depot to call, and that warm transfer is going to Loan Depot, that's it. You cannot transfer that call anywhere else. It has to be just to that ultimate seller.
Okay, excellent. So also another one, if we verify the fact that we are manually dialing, do none of the updated FCC rules apply?
I think I exhausted this. I put an asterisk, a big asterisk.
Don't do that. Tell them, Puja, don't do that.
You can put a crown next to it, right, instead of an asterisk. But the rules, as defined, does not alter the language of prior express invitation, which would allow you to use a very, very true manual system that you have got vetted by your outside counsel or Trotman Amin before utilizing. But I do caution, we don't know how that's going to play out in courts. We don't know how hard the MCLC, the FCC, the state AG's offices are going to push against that rule. But more to come, but I think for now you are safe to make calls using a true manual human selection system to make marketing calls that aren't on the national DNC list or where you have prior express invitation.
And I mean, after all, the rule is aimed towards automated calling and pre-reported calls. And it does list that it is an exemption if you're not doing that. You're manually dialing and you're not making AI calls or pre-reported calls. But like Puja said, have your system verified. Only you and your attorney can tell you that, but get your consent too.
Yeah, when a customer revokes their consent via text saying stop, does that mean they can't be called?
Yes, thank you for that, whoever asked that question. Yes, any revocation now, that I can't believe I missed that. Thank you, audience. The revocation ruling also addressed this piece. Stop notifications now from a text message also means you can no longer call them. If you receive a stop to a call, you can no longer text them at all either. This is a huge new shift, but now it is a global text call opt-out.
Right. A call has always equaled a text. So this is clarifying it, making it clear to everyone. It's the same thing.
Yeah, so the one-to-one consent rulings also included a provision where they have codified that text messages are calls under the TCPA. All of us TCPA attorneys out there have already been treating it as such. The courts have been treating it as such. So that wasn't news to us. It was just put into stone. And now with the revocation rules, they further clarify that the text messages and calls are treated equally for purposes of consent and for purposes of the revocation rules.
Okay. When will the one-to-one FCC consent rules take effect? How much time do we have?
Like I mentioned, 6 months until the commission finishes their review. We don't know when they're going to finish that review. That can take months. I'm not sure. I will announce it as soon as I can on TCPAWorld or when I find out. But it'll be 6 months until the review is completed.
But the one-to-one consent rule, that component is January, right, of next year?
That component is 1 year, 12 months after it is published in the Federal Register.
Okay, excellent. Okay. Questions about franchisees. If one-to-one was sold to many franchisees owners, for example, insurance company, and a customer opts out to one of them, do all the franchisees need to honor that opt-out request?
So this is going to be interesting both on the consent side and the opt-out side. So you're going to have to look probably back at to how the consent was obtained. According to the one-to-one rules in the franchise model, especially if it has to be logically and topically rated. So if you're in the franchise model selling different services or products, one, you have to make it logically and topically related when you're obtaining the consent. And two, under the order, I believe that you will not be able to obtain consent for multiple franchisee entities, right? So that's going to be very difficult. So if you are obtaining consent for that one entity, then it is reasonably okay to assume that the opt-out request is only going to apply to that one franchisee, not the entire enterprise. But where you're going to have more difficulty is getting that consent for that one franchise, as opposed to getting consent for the entire entity and for all of its franchisees to make calls or text messages.
Okay, so we'll try to translate another one. We have a consumer who tells us to stop through a lead aggregator, and then within a week we receive from another company. Does that mean we're not allowed to call that same individual?
Yes.
There's some nuances with
that is a tricky question.
Yeah.
It depends on the company if you opt out with that company, and then you get a call from another lead generation for that company, you opted out from that company. That opt-out is good for that particular company.
Correct.
Next, revoking consent. If a business does not employ SMS as a communication method, can a consumer use SMS message to revoke consent? Interesting.
Can you repeat that one, Ben?
If they do not use SMS as a communication method, can a consumer use SMS to revoke consent?
Then
that's a reasonable means. Yeah.
It's a reasonable means, and you're going to have to opt them out from calls.
Right.
Because you do not test.
Okay. And let's see if we got one more question we can grab. Registered, scanning through. What about if they call us from a radio or television ad? So inbound calling.
What about it?
Yeah, that's what I was going to say.
Yeah.
Good for you. Driving inbound calls.
Congratulations.
Do not call them back. If you get a missed call, just note that you can't call them back if you're using regulated technology without prior express written consent.
Yeah, let's take it at that. They can call you, not advised to call them back. If it goes through. Okay, excellent. So we talked about a lot of topics here today. I'd like to ask each of you just a takeaway topic from all of these things that the industry is grappling with. What are some takeaways?
Takeaways. For me, I mean, the comment period is closed for the one-to-one consent ruling on Monday. You know, the last comments were received from the small businesses. If you didn't participate on that, you should be asking yourself why. Reach had continued to have meetings with FCC and really pushing for the industry to help you folks out. But now, you know, there's no more comment period. We're moving forward as is. Things, if you're a buyer, if you're a lead buyer or an ultimate seller that you want to start thinking about are who are your partners that you're going to work with? What are you going to require of your consent forms? How much are you going to pay for these leads? I think placement is going to matter a lot for the buyers of where they're placed on the consent form. Thinking about what kind of data points you want to receive from your lead seller, updating your contract terms, that's going to be huge. If you don't have contracts, get some contracts in place immediately. And just, you know, a lot of folks aren't shifting yet, but you need to start having these discussions with the industry. And for you lead sellers, if you're not working, especially if you're a small guy, you're not working with the bigger brands, you're going to have to start pivoting into different marketing strategies or, you know, trying to work with buyers perhaps on a one-to-one basis. Organizations like Reach, for instance, is going to allow you to work with good, compliant organizations that can assist in leading new folks in the industry. Additionally, obviously, Reach is going to continue to apprise you of the new rulings and the new impacts, you know, how litigation is going to play out. And more importantly, we're going to continue to lobby where we can in front of the FCC for, you know, for other rulings that might come out, including the Do Not Disturb Act, which we didn't even discuss here, but that would be a whole different webinar to go through that act in particular.
Yeah, Tammy, key takeaways from you.
So, you know, I'm just real big on compliance. I just think a lot of our audience may not understand the compliance world. If you have legal counsel, that's good, but you need a compliance officer in place as well to understand all the telemarketing regulations, to help you understand what right do you have to call, to run your calling list through that test. You know, do I have consent? Do I have a relationship? Am I using technology? Am I manual dialing? What do the states say? So you just really need compliance as part of your organization and as part of your practices. So have a compliance professional in place as well. You know, in my role, I can interpret a lot of it and take it to legal counsel, and then, you know, act as the liaison to my company. You know, sometimes these things get complicated, and if you're not living in this world and you don't understand them, it's hard for the business to communicate what they want to do directly to their attorney sometimes. It's good to have a compliance professional in place that's living in the day-to-day that can take what the company wants to do, talk to legal counsel, translate all of that, and collectively come up with a plan for compliance.
Absolutely, 100% agree, and verbal repost of everything that you just said from my perspective. So for sure. So a few things to plug before we close out. Puja, some items and sites and places you're going to be located at. What's coming up next for you?
For me, I will be speaking on next Tuesday in Arizona with the DNC folks. Love those guys. We put on a great show. We're going to dive really, really deep. You guys just got the general overview. We're going to help you folks engineer to yes, help you folks come up with new creative marketing strategies. I am coming with Bizarre. I'm coming with two of my highest, most efficient, amazing litigators, the Dame and the Baroness. And then also I'm bringing the Duchess along with me, our state law wonk. So, you know, you're gonna have a ton of resources there. If you haven't signed up, I really encourage you to come, especially if you're on the West Coast. You won't want to miss that event. I have a few webinars that are coming up that you can find on TCPAWorld.com. And yeah, just keep on TCPAWorld.com and we'll continue to break things down as we receive news.
Excellent. Tammy, where can they go to learn more about Convoso's compliance solutions?
I did put the link into our information. We do have a compliance page on our website that offers all types of tools to support compliance, lots of reading material, and I'm available for contact as well. So
yeah,
visit our site.
excellent resource. I was looking at that as during the preparation, so I highly encourage everyone to go there. Also want to ask everyone to follow Active Prospect on LinkedIn. We got regular updates, posts, more webinars are going to be coming in the weeks ahead. We'll continue this series. Take a look at our registration for our next topic. I'm also going to be at that Compliance Summit in Arizona. That is the place you need to be for TCPA deep dive information and compliance. And then Active Prospect is also going to be at LeadsCon in April, so looking forward to it. Thank you both very much for your subject matter expert and knowledge expertise. There was one question that was unanswered. It was, why is Queenie so awesome? And we just don't have enough time to cover that today, so we'll have to save that for another time. But thank you all. Thank you, everyone.
Thanks all.
Thank you.